Good afternoon, everyone, and welcome to the webinar, Technical Evidence in Stalking Prosecutions, Where to Get It and How to Get It In. My name is Charlie Whitman-Barr, and I'm an Associate Attorney Advisor at Equitas, the Prosecutors Resource on Violence Against Women, and I will be moderating today's webinar. Today's webinar will cover the applicable rules of evidence and relevant case law associated with proving a technology-facilitated stalking case, and will provide strategies on when and how to introduce technical evidence and overcome common objections at trial. We want to start with a quick polling question, so if you can let us know what discipline you're coming from: A, prosecutor; B, law enforcement; C, advocate; D, other, and you can use the feedback option to your left to answer the question. We'll just give you a moment to do that. Before we begin the substantive portion of our program, I'll provide a brief overview of our iLink webinar service. You can listen to this webinar either via your computer or a conference call. For the best use of iLink, we strongly recommend calling in from a landline to our conference line, which is 530-881-1212, passcode 202-731-738. And that number is also in the upper left-hand portion of your screen. If you're using a mobile phone, please do not use the speaker option, but listen with an earpiece. If necessary, all call-in participants have been muted for the duration of today's webinar, which is also being recorded for later viewing. You can also connect to today's session using the Internet audio option on your start screen. You can do this by clicking the Connect button on the start screen. If you use the audio option, please do not also call into the webinar. Only do so if you experience difficulty with your Internet audio. If you experience technical issues, please use the iLink hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen, above the presenter's photo and to the right of the conference call number. You can also contact iLink directly at 1-800-799-4510. Throughout today's webinar, we encourage you to post comments and questions via private chat to me, Charlie Whitman-Barr, and I can share those questions anonymously with our presenters to address during today's presentation. Please note that public chat has been disabled for today's presentation. Today's webinar is hosted by Equitas, the Prosecutors Resource on Violence Against Women, through funding from the U.S. Department of Justice Office on Violence Against Women. Written materials, including a copy of today's PowerPoint presentation, will be provided to you following today's presentation, as long as with our copy of our presenters' biographies. Equitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Equitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. Equitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. We're joined today by Elaina Roberts from the Stalking Resource Center. The Stalking Resource Center is a program of the National Center for Victims of Crime, and the mission of the Stalking Resource Center is to enhance the ability of professionals, organizations, and systems to effectively respond to stalking. The Stalking Resource Center envisions a future in which the criminal justice system and its many allied community partners will effectively collaborate and respond to stalking, improve victim safety and well-being, and hold offenders accountable. The Stalking Resource Center also provides training, technical assistance, and resource materials for professionals working with and responding to stalking victims and offenders. Today's presenters are Elaina Roberts, Program Attorney from the Stalking Resource Center, and John Wilkinson, Attorney Advisor at Equitas. Elaina provides technical assistance and training on all aspects of stalking to law enforcement, prosecutors, victim service providers, and other professionals. She also conducts legal research and analysis on current state and federal stalking laws, case law, and legislation. Prior to joining the Stalking Resource Center, Elaina was an assistant district attorney in Albuquerque, New Mexico, where she prosecuted cases in the violent crimes, community crimes, and metro divisions. Prior to joining Equitas, John was the program manager for the Gun Violence Prosecution Program, the Homeland Security Program, and the Southwest Border Crime Program of the National District Attorneys Association. He also served as an assistant Commonwealth attorney in Fredericksburg, Virginia, where he was a member of the Fredericksburg Area Sexual Assault Response Team. I'd now like to turn the floor over to Elaina and John.
Thank you so much, Charlie. I appreciate that.
Sorry.
Hi, everyone. Thank you for joining us again today. And we want to give you just a heads up on where we're headed today and some of the things we're going to be discussing. We want to look at how to identify and preserve the technical evidence that comes our way when we're dealing with a stalking case, how to overcome these evidentiary challenges when we try to admit some of this technical evidence during the course of a trial. And we're going to spend some time looking at how we can coordinate and collaborate with some of the other professionals that are in our own communities as well as those that are nationwide. With that being said, I want to take a quick poll, if we can, for those of you that are listening, and I want you to type in your answer regarding how many people you think are stalked in 1 year in the United States. Do you think it is A, 1.2 million, B, 3.4 million, C, 5.5 million, or D, 7.5 million? Please type in your answers now.
And it looks like as we're getting responses back that about 50% are saying B, 5.5 million, with 33% saying B, 3.4 million, and just around 17% choosing A for 1.2 million. Kind of how the numbers are coming in now.
All right, great. Thank you, Charlie. And we know actually that 7.5 million people are stalked in a 1 year period in the United States. How do we know this? We know this because the Centers for Disease Control provides an annual survey. It's a random sample telephone survey that's called the NISVIS. It's the National Intimate Partner and Sexual Violence Survey. This comes out every year, and one of the things they look at is the stalking prevalence across the United States. During their random sample telephone survey, the number that they came up with is a 7.5 million. There are a couple of caveats to note with this study. One, it only interviews people over the age of 18, and as I'm sure can imagine, stalking does begin in some instances prior to the age of 18. The other thing is that during their interview and their survey, they use a very conservative definition of fear, and as we'll see in a second, fear is one of the elements of a stalking case. And so the way they describe it is very fearful. Something made the person feel very fearful, and that's a pretty conservative definition. So if we take those two things into consideration, it's likely that the number will increase if we were to just ask someone if they felt any level of fear, and if we also included people under the age of 18. You can calculate your own statistics in your own communities by taking really the 4% of your population for women and 2% of your population for men, and that should give you the statistical number of stalking cases that you should be seeing in your own jurisdictions, whether that's within your own communities or statewide. Those are the numbers of cases that hopefully are coming through either by law enforcement or being prosecuted. I would venture to guess that many of you aren't seeing near that many number, but again, if you wanted to take a look and see what your own jurisdiction would be having, that's how you would do that. And so when we look at most stalking statutes, we know that they all differ. Even though stalking is a crime federally in many of the tribal lands, as well as all 50 states and the District of Columbia and the U.S. territories, every statute is different. Every statute is not only different, but their definitions of how they're going to define certain things is also going to be different. With that being said, though, there really are three main elements that you should be looking at as you read your own stalking statute. And the SRC on their website does have all the stalking statutes listed alphabetically by state if you just wanted to look yours up after we're through today. The first one is course of conduct. That's your first element that you're going to come across. Sometimes you'll see it referred to as a pattern of behavior. And when we look at a pattern of behavior or course of conduct, typically what we're looking at is two or more acts, two or more incidents. Now, again, you need to look specifically not only to your statute but your case law, because there are a few states out there that require 3 or more behaviors, 3 or more acts by the offender. But generally speaking, it's going to be 2. And that could look like anything from 2 text messages 2 emails, 1 phone call, 1 text message, 1 Facebook post. You get the idea. But you're looking for that course of conduct, which is unlike any of the other crimes, which are typically one incident type crimes. The second thing you're going to come across is an element of fear or emotional distress. And when you look at fears, you're looking at the level. So does your statute require fear of physical harm or bodily injury, or does it require something along the lines of death or intimidation, or that the victim is being terrorized? You want to look specifically at what fear your statute requires. And then look also to the standard. So in parentheses, you can see we talk about the actual or potential for that. When we look at the standard of fear, your statute is either going to require you to prove it based on a reasonable person standard, or that the victim actually felt fear. So if we look at a reasonable person standard, you're asking the trier of fact, which is either your judge or your jury, to decide if they were in the victim's shoes, would they also feel the same level of fear that the victim is feeling? If you're dealing with an actual standard, then of course you need to prove that the victim was actually afraid of what the offender was going to do. And finally, your third element is going to be some level of intent. So it's either going to be a general intent crime or a specific intent crime. If you're looking at a specific intent crime, that means that you have to prove not only that the offender did these acts, but that he intended the consequences of those acts. If you're dealing with a general intent statute, really you just need to show that the offender intended to do those specific acts, but that he or she didn't necessarily intend for the consequences of those acts. And so when we look at the reporting, the research indicates that 60% of stalking victims do not report to police, and this could be for a number of reasons. Many victims feel that the officer would be ineffective in their response, that they wouldn't be able to stop the stalking behavior, or they believe that the police officer wouldn't believe what they are saying, or that they wouldn't think it was important enough to write up a report. We know that 20% of victims minimize the stalker's behavior, or they think that it was a personal matter and that they should be able to deal with it on their own. We also know that sometimes fear of the offender's reprisal can be a factor in determining whether they choose to report or not. But many victims will not recognize what's happening to them as stalking behavior. As we'll see, many stalking behaviors are not criminal in and of themselves. So when I reference things like text messages or emails or Facebook posts or showing up in public places, in and of themselves, that is not criminal behavior. But it's when you start to put all those pieces of the puzzle together to form that course of conduct or that pattern of behavior, that's when you have the criminal conduct that's taking place. And there are additional barriers to victims being able to report. So a lot of times, and this is unfortunate, the collection of that evidence is going to fall solely on the victim. They are going to be in the best position to collect all that evidence and turn it over to law enforcement. But in many instances, the victims will feel that they don't have enough evidence to turn over. They don't have the link that links back to the defendant proving that he or she is the one doing these types of behaviors. We know that events appear to be coincidental rather than criminal, as I mentioned before, so things like showing up in public places or the fact that there's just a couple of text messages coming in. Again, it doesn't appear to be criminal behaviors, and so a lot of times victims will think that because it's not criminal, they can't report it. And then disclosing this type of behavior to law enforcement can sound unbelievable even to the victims themselves. So if they're dealing with weird things that are happening on their computers or weird things that are happening on their cell phones, say, for instance, spyware has been installed, it sounds unbelievable to them, and so they think law enforcement won't believe them. But one thing I would say is that we have to suspend our disbelief, because if the technology is out there, most likely someone has found a way to misuse it and to use it in a way to stalk the victim. When we look at the technology and how it intersects with stalking behaviors, we see that oftentimes we're dealing with multi-jurisdictional events. So technology allows a stalker to be in a different county, in a different state, maybe even on a different continent, and still able to stalk their victim. And John will discuss with you what some of those jurisdictional issues might mean when you're trying to prosecute a case like this. We know that a lot of victims feel frustrated that they're hearing from law enforcement that there's nothing we can do, again, because these behaviors do not seem to be criminal in and of themselves. And what's key to know when you're dealing with a stalking case is that fear is a big element that you're going to have to deal with. And fear is hard, or difficult, I should say, to conceptualize because it's subjective. What makes you fearful doesn't necessarily make me fearful. And even if we are afraid of the same things, we might experience that level of fear or that fear at different levels. Additionally, people don't admit to being fearful of something, especially if you're dealing with a male stalking victim and how society deals with that. You might hear victims say that they're just annoyed, that they just wish the behaviors would stop. And oftentimes, victims will try to deal with the stalking behavior long before they even report that to law enforcement. And then again, when we look at fear, even if we are scared of the same thing, we still might not react to it in the same manner. And so that makes, looking into the stalking case and prosecuting these types of cases to be somewhat challenging. And then in addition to that, we do have to convince a judge or a jury that this behavior is serious and it is criminal. When it comes to technology that's being used to stalk, we know that the technology is outpacing the statutes that are currently in place. And that makes sense. When we look at how progressive technology can be, once it begins, it can progress rather quickly. And of course, our statutes can't keep up with that. So that's going to be one of the challenges. Also, it can mask identity. So whether you're dealing with spoofing or anonymous emails, and I hope that many of you took our online course on how technology is being used to stalk, because these are some of the ways that it can be used. They tend to mask the identity of the stalker, and it can make it a little bit more challenging for law enforcement to investigate. Again, we know that it crosses borders jurisdictionally, and it may be costly to investigate, not only from an actual cost standpoint. In other words, you might have jurisdictions that can't deal with the level of technology. They might have to send out to have certain things forensically analyzed. But then we look at the incidental costs. We know that stalking is a course of conduct crime. Many of these cases are going to last, on average, 2 years. The majority of stalking cases will only last 6 months, but intimate partner stalking cases tend to last longer, and as I indicated before, the average time is going to be about 2 years. And so when we look at these cases, we know we want to be preserving the technological evidence quickly, because inevitably it's going to be erased, it's going to be lost, or the cell phone company or the company that you're dealing with isn't going to retain it for very long. You also want to know who you can contact, who is keeping this type of information, how long are they keeping it, and how do you go about requesting it. And when you're requesting this type of technology, what you're looking for is something that's going to link it back to the defendant. So when you're looking at social networking sites or you're looking at an internet provider, you want the information that's going to link back to the defendant. There is, however, some good news when we're dealing with technological evidence in a stalking case. And that's that it provides evidence where none existed before. You now have that technological link where you can follow basically the crumbs that will lead you back to the offender. And nothing really disappears online, although it may be difficult to locate. So while technology may present complicated issues, the good news is the rules of evidence and how you're going to get that evidence in at trial are the same. And with that, I'm going to turn it over to John.
Great. Thanks, Elaina. We'll talk about some of the common objections and some of the rules that are commonly invoked when you have a technological evidence involved in your case. And here's just a list of the common ones. These are by no means all of them. People come up with creative defenses all the time and legitimate defenses all the time. So we have to be prepared to meet those. But relevance, just basically, and authenticity are going to be the two that are sometimes overlap or intertwine. Authenticity is just our ability to prove that what we're saying this evidence is, it actually is. And the relevance may hinge on being able to tie it to the suspect, the defendant. How do we, because technology masks identity, how do we prove that this is the person that actually sent it? And are we just relying on the fact that it came from their cell phone or came from their email account? Because that's probably not going to be enough to demonstrate that it was that individual. Hearsay is also going to be implicated in these cases because these are going to be out-of-court statements. But typically, because they're generally in stalking cases going to be threats or some sort of message or something from the defendant, then there'll be an admission, and it's an exception to hearsay, or in your jurisdiction, it may be considered not to be hearsay at all, an admission from the offender. But again, that's going to tie back to, can we prove that it was that individual that sent it? Sometimes we might try and introduce technological evidence, not for the truth of it, the content, but maybe to demonstrate knowledge or something like that, and then hearsay wouldn't be implicated. The best evidence rule might be implicated also, just whether what we're producing in court is an original or is it a duplicate that's acceptable, or are there going to be some problems or objections related to that. That becomes less and less an issue as our ability to duplicate things exactly as they were is greater and greater. And then again, even relevant evidence can be excluded by the court if its probative value is outweighed by any unfair prejudice that it might manifest against the defendant. So we'll talk a little bit more in detail about each of those things. This is just the federal rule of evidence that talks about what relevancy is. And again, this is going to be relevant probably only if we can tie it to the defendant, only if we have a way to demonstrate that the defendant sent this message, this text message, this phone call, this email. And with new technology, some of which Elaina mentioned, and again, if you haven't taken that online course, just go ahead and take it when you get a chance. You can come back to it. You don't have to do it at one sitting, and it'll tell you about all of these things. But spoofing, so these technologies that are designed to mask who is sending, making a phone call, or who is sending a text message or an email, now our job becomes a little more complicated. And if we can't demonstrate that it's tied to that defendant, and the evidence will not be relevant and will not be admitted. So we have to be careful about that. Authenticity is really the main one. Like, how are we going to demonstrate that this actually is what we're saying it is, i.e. an email sent from this individual, a text message sent from this individual. And there are ways to demonstrate that, and the burden is not huge. We just have to be able to satisfy that it is what we say it is. And so we want to pay attention to that, and we'll talk about some of the ways we do that with specific cases in a minute. Hearsay, again, because these are messages coming from the accused, the offender, the defendant, that should be an admission, and that should be acceptable. There may be other hearsay exceptions that allow certain evidence in. There may be hearsay exceptions that are related to things that the victim wants to introduce, like perhaps if the victim kept a log of all the things that were done, all the statements or emails or text messages that were sent, rather than save them on their phone. They can still testify about that stuff, and it might be past recollection recorded is the hearsay exception that allows that to come in. So we want to pay attention to our different hearsay exceptions in these cases as well. The best evidence rule, again, it's going to talk about original writings, recordings, photographs, things like that. And what is an original when we're talking about technological evidence, electronic communications? What becomes the original? And we'll talk a little bit about that. Typically, duplicates are admissible to the same extent as the original, unless there's some real issue as to the authenticity or the circumstances that make it unfair to admit the duplicate. And usually that's not going to be an issue, but it could be. So we want to think carefully about what we're trying to introduce in these cases. There's exceptions to the best evidence rule as well that we should be aware of. If the original has been lost or stolen, or destroyed in some way, if it cannot be obtained, if it's in the possession of a foreign government or some place that you do not have power of process to compel somebody to produce it for whatever reason, then a duplicate would be acceptable. If it's in the opponent's possession, then a duplicate is acceptable. And the theory there is you just have to give notice to the opponent that you intend to introduce the duplicate, and their remedy is to produce the original if there's an issue as to the genuineness of the duplicate or the genuineness of what is contained in the duplicate. And if it's also not closely related to an issue in the case, if it's a collateral issue that a duplicate is admitted on, then they may not hold you to the best evidence rule. The duplicate would be acceptable when the original is not. So an original of a writing or recording is the writing or recording itself. But for electronically stored information, it could mean any printout of that information or other output that's readable by sight if it accurately reflects the information. So when you think about it, if I get emails that are threatening, do I have to bring in my computer and show you where I received them in my email account? Which you could do. You absolutely could do that. Or I have to bring in my phone and show you my phone where I got the text messages or the phone call or the voicemail. And you absolutely could do that too. But you don't have to do that. You can print those things out. You're not required to go to all that trouble to bring that those pieces of equipment in. You can print those things out, and as long as you can establish through testimony that this accurately reflects what was contained in the email, this printout is exactly what the email was, then you should be fine, and that should be accepted as an original. And it's very akin to a photograph. Anytime we're trying to get a photograph in of a crime scene or an injury or something like that, and you have a victim or a witness who saw that scene as is, who can testify that the photograph accurately depicts the scene at the time, then the photograph should come in. It's the same thing with the emails, text messages, voicemails, things like that. Voicemail may be a little different because it's an actual recording of somebody's voice, so it's difficult to alter that. So the court may exclude this evidence even if it is relevant because of some unfair prejudice. It's not just unfair prejudice, but that's the main one that the defense typically objects to. So think about an email that you want to introduce that contains a threat, but might also contain, say, an admission of a prior crime, or or say something that people might frown upon, like use of pornography or something like that. So can that come in, or is it going to be overly prejudicial, or can we just redact out those things that are prejudicial and still get in the relevant, important piece that contains the threat or the information that demonstrates that the offender is stalking the victim in this case? Think about those things as you're doing this. So text messages, what are we going to produce to demonstrate that there was a text message sent? Can we do a screenshot? Or very often officers will just take a digital photo of the text message on the victim's phone, which is completely acceptable. Screenshot also, it's going to have to be somehow downloaded, printed out, something like that. The phone itself is always fine. Computer, if you receive a text message via computer, or if it's downloaded to a computer and then printed out. Records from the phone company or the messaging company. The problem there is that to get content in of a text message, most phone companies are not going to have that information, and if they do have it, they don't keep it for very long. So we have a chart in a little bit that talks about some of the specific phone companies and their practices, which you need to check with regularly because they can change those. They don't have to give us notice about that. A printout of whatever the text message was, or a cut and paste, or a handwritten transcript, as long as there's a witness to say that this is what the text message said. I wrote out word for word from my phone onto a piece of paper, and this is exactly what it said. Or an officer can do that and demonstrate that this is exactly what the message said. Who can authenticate that that is what the text message is? The person who saw the message, the recipient, sender, or third party. So it could be the victim who got it. If the person who sent it acknowledges that they got it, if we're investigating and interviewing our offenders and they're talking to us about what happened, get as many admissions out of them as you possibly can. Have them tell you if they sent those things or not. And not just that, you can prove a lot of this through circumstantial evidence as well. And so we want to ask them questions, even if they won't admit that they sent a particular text message or made a particular call. Circumstantially, can we ask them about, well, who had your phone at this time? Is your phone password protected? Does anybody else have the password? Do you share your phone with anybody else? Where was it at the time, during this period of time or on this day when these messages were sent? And then maybe you can tie it over to the message. The person can testify what the message says. Screenshot or the actual phone can be used, but a person can also testify from their recollection. That's not going to be the most powerful way to prove this case, and that's not going to be the best evidence in that case, not via the best evidence rule. That doesn't apply to someone's testimony of this. But they can testify about what happened, but that's going to be extremely subject to challenge. And so we want to prepare the strongest case possible and probably not do that. But I'm not going to drop a case because that's my only evidence if I have enough evidence to go forward and I have other evidence to corroborate what the victim's telling me. I'm not going to abandon that. So we should think about those things. And phone records can also, and another good circumstantial case is even if you don't have the content from a phone company, but you have the phone records to demonstrate that calls were made from the offender's phone or text messages were sent from the offender's phone at a certain time, and that matches up with what's on the victim's phone. That's powerful corroboration that it was sent by the offender, or at least from his phone. You're going to need a little more because the courts have basically said just saying that it was sent from a person's email account or from a person's phone is not going to be enough to authenticate. You need one piece more or a couple pieces. So those are powerful pieces of evidence that corroborate that it was sent or establish authenticity. They're just not enough alone. So don't ignore those things. They're very important, but you're going to need one additional piece to go along with that. There's a couple case examples in here. In this Gagliardi case, which was a federal case where it was an individual who was soliciting sex from a 13-year-old online, and of course it was a sting operation. There was an informant involved who allowed the federal agent to gain access to a particular chat room where this sort of thing went on, and he pretended to be the 13-year-old girl and engaged in conversation with this individual. And then the officer just printed out the chat, the content of the chat, printed it out, the contents, and produced that for court. And the defense challenged it, saying that it was easily manipulated and could have been altered, et cetera, and it still doesn't establish who was on the other end of the chat. He was using a screen name. But they had testimony that indicated from both the informant and the officer that this was exactly what the content of the chat was. And they ultimately set up a meeting time in place for the person in the chat room to meet the 13-year-old girl, and sure enough, the offender showed up. So they were able to nail that down pretty effectively, and that's a good way to do it. That's more than circumstantial evidence, or it's extremely powerful circumstantial evidence, so you can see why the court would be fine with that. In the Tank case, also a federal case, this was a child pornography case, and they were able to tie the defendant to the communications that were sent because of the screen name the individual used. The individual also showed up for a meeting that demonstrated that clearly this was the conversation that was going on. But the unique issue here was that, again, there was an informant involved. I guess, a co-conspirator, you would say, in a child porn case who was involved in distributing child pornography. He would keep records of the conversations that he had with the different members in this particular chat room, but he wouldn't keep all the conversation. He deleted out things that weren't related to sex with children or pornography, but collateral conversations. And so they said, well, these are inaccurate because they don't contain all the conversation. And the court said, no, that's okay. You can argue that before the jury. That's going to go to the weight of the evidence, not to the admissibility. And you can certainly argue that there were things that were cut out that might have indicated that you were not interested in child pornography or interested in participating in this. But the co-defendant or the co-conspirator who testified on behalf of the state said the only things he cut out were things that had nothing to do with sex or pornography, and that all the things that were in there clearly demonstrated that he wanted the materials that the other individual was offering. So again, some challenges, but the state was able to meet those challenges. In this Roseberry case, this was a breaking and entering case, and they properly authenticated these text messages through testimony of the recipient, who was the victim in the case. And this is an odd sort of domestic case where the person who burglarized the home, the victim's home, was a former romantic partner, and texted her prior to breaking in, basically acknowledging he was going to break in. And then they were able to tie him to things that were stolen from the house. He didn't say he was going to steal anything. He just wanted a place to stay, and she had locked it up, and it goes back and forth. But basically, based on her ability and the content of the messages, she was able to establish that these were authentic and came from that defendant. And the same in Jackson v. State, which was actually a cyber stalking case. In that case, the offender, the defendant, acknowledged when he was presented with the conversation by the detective that those were in fact things that he said and sent. So that's always a great way. It's a confession essentially to the crime. So that's always a good way to establish that. And then the detective was also in that case able to testify that this was an accurate account of the conversation. But again, you always have to tie it to that individual. So it's sort of a two-pronged thing. Yes, I can establish that these authentically represent the conversation that was had or the messages that were sent. But the second part is the trickier part. How do I know that it was from that individual? And so think about your witnesses and how you're going to lay a foundation for this evidence. Is it coming from a known phone number, a known email account, or is it being spoofed, or is it unknown to the victim? And so your victim alone may not be able to establish that this is from the defendant unless there's circumstantial evidence contained in the messages, things, nicknames, things about which only the offender or only a small group of people would have known, and that there's other things, the offender's motive to do this that may be established through other circumstantial evidence. But you've got to somehow demonstrate that it was the offender that sent that. In the Gibbons case, this was a case that involved a drug conspiracy, and they said that the court erred in admitting the text messages from the cell phone of one of the defendants, that they failed to establish the authenticity or the reliable of the messages. And really what happened in that case, it was key to establishing a drug conspiracy case, and they seized the offender's phone, but they were unable to put on any evidence to suggest that the offender had ever read the text messages on his phone or received them, had seen the content, or about who they came from. And while the content and the conversation did establish a drug conspiracy, there was no way to really tie it to the offender except that it was his phone to really establish. So even when you think that, hey, this is enough, this is his phone, and you've got all these text messages and all these things that indicate that they're going to buy and sell drugs, it may not be enough. You might have to go that extra step. So don't stop there. Do everything you can. Always talk to the offender. Always try and get admissions. Always talk to him about the security of his device and the lack of sharing of that device to maybe circumstantially establish that he was the only one who could have sent these messages. Receiving messages is another issue. Demonstrating that somebody saw something on their phone, it would be a slightly different issue to prove, and you might have to get an actual admission from him there. In the Rodriguez case, this was also failure to authenticate some messages, 10 out of 12 text messages. This is an odd case, too, but basically these two individuals broke into a woman's house and raped her, stole her phone, and started sending text messages after the sexual assault to the victim's boyfriend, and he turned it over to the police. And two of the text messages, they said, were thoroughly authenticated because they were riding a bus, and the bus had a video system that showed the two individuals with the phone at the time the text message was being sent, and they were clearly using the phone to send a message. And then they said the other 10 were not captured on video, and so those were not authenticated. And so that was a problem, which I wouldn't have thought would have been a problem. I would have been caught in this case as well. But they ultimately said it was harmless error, and the individuals were convicted because they stole her credit card, they used it, were caught on video immediately after after the crime, and so they were able to do it. But that's just an interesting issue with those text messages and why they would send them, who knows. But you would think that would be thoroughly corroborated or authenticated, and it wasn't, according to the Nevada courts. The Coke case is another one where authenticity was an issue. It was a drug case. The prosecution offered no direct proof or testimony of recipients or other possible authors of the messages, and the messages' contents did not provide circumstantial evidence as to authorship. So it's another case where a phone is seized. This is a woman who was involved, allegedly involved in a drug conspiracy case. Based that the phone was right near her when they seized it, but based on what they were able to present and the fact that either they didn't question her about it or she didn't make any statements about it, they couldn't demonstrate the authenticity of those messages. So, again, that's a problem. We might not normally think that's a problem, but it can be a problem. So let's keep that in mind. And you really got to thoroughly investigate these cases to establish this. And we should be thinking authenticity and relevance, meaning are these messages from the offender? Two things. Do these messages accurately, does our evidence accurately reflect what was contained in the message? And does it come from the offender? The two big things that we have to demonstrate there. The forms of evidence on some of these things, screenshot or digital photo of a call log, the phone call logs, records from the phone company that can tell us when phone messages were made, how long they were made, things like that can really help us present these cases effectively. What do the records include from the phone company? It can be that metadata, who the caller was, the text number, the time of the call, the length of the call, things like that. It can't tell us exactly who the caller was. It can just tell you whose phone it came from. Some companies may have text content, and we'll talk about that. It could be a business record. You could have somebody from the phone company talk about it, or it could be one of the parties prints it out and can testify that that's their bill and that's their it's authentic and it's accurate to their recollection. So business records, testimony from the account owner, a third-party witness that may have knowledge of it, or consent of the parties could be a way to get that evidence in. Emails, same thing. In this case, Commonwealth versus Purdy out of Massachusetts, this was a guy who was running a prostitution ring out of a hair salon, and he had a bunch of emails setting up the transactions and having people meet up with the women who were being prostituted. And the court determined that they had to find by a preponderance that the defendant authored the emails, and that was the standard of proof for the authentication. Some of the other cases talk about maybe a slightly lower burden of proof, that it was that there's a reasonable likelihood, and that it's a minimal threshold to overcome. A low threshold and reasonable likelihood are used in a lot of the federal cases. A reasonable likelihood that these are the messages that were sent from the offender or the accused. The evidence that the defendant's name is written as the author of an email, meaning he had like an e-signature or just signed his initial at the end, and that it originates from an email or social networking site associated with his name, that typically we just say was his, is not going to be sufficient alone to authenticate the electronic communication as having been authored by him. So that's an important case, and that's an important thing to think about. In this case, they had a lot more evidence to establish that he was the author, so they didn't have a problem. And it included things like the contents of the emails, him signing with certain things in each email, that it came from his account, that one of the emails had a photograph of him, and one of the emails explained in great detail all the different services the salon had to offer. And so all of those things together, the court felt were sufficient to meet that burden of preponderance to establish that he had written the emails and they came from the defendant. So it's probably not one piece of evidence. It's probably a whole bunch of pieces, and all those things are going to be important, so let's gather them all. Venue is another consideration in these cases. This is a North Carolina cyber stalking statute that explicitly addresses venue and basically says that you can prosecute somebody for the crime of cyber stalking anywhere that an electronic communication originated or anywhere that it was received. And so that's very helpful to have that addressed explicitly. Not every state addresses it explicitly, so you're going to have to check your own state to figure out what the rules are in your state. But typically, this is going to be acceptable. For stalking in general, just one piece of the course of conduct of stalking has to occur in the jurisdiction where you're prosecuting to establish jurisdiction and venue. You do not need to have everything happen, or you do not only have to rely on those things that happen in your jurisdiction. Just one piece of the course of conduct has to happen in your jurisdiction. So for electronic communications, what is that going to be? It could be the phone call. It could be the text message received in your jurisdiction or sent from your jurisdiction. Typically, if you're going to prosecute a defendant in the jurisdiction where he resides, where he sent these things from, you're going to be okay. And typically, if it's where the victim received them, you're going to be okay. There are also theories of venue where an email has gone through a server in another state, and sometimes people try and establish venue that way. Just check your jurisdiction's laws or contact us, and we'll check them for you, and that's going to be the most helpful way. 404B evidence is another thing to think about in these cases because it can be helpful, particularly in technology cases where identity might be masked. If somebody has done this before and maybe sent identical communications or very similar communications, then that can be helpful. So let's always look for that. This chart just talks about some of the different phone companies and what their practices have been. It's from the Department of Justice, but it's back in 2010. So just check in with your phone company if you have a case with them, and check in immediately as soon as you can because the evidence is likely to go away pretty quickly. And content in particular, most of them don't retain it, and those that do don't retain it for long. Elaina?
So anymore, most stalking cases that you're going to be dealing with will have some form of technology that's being used. I would say it's going to be a rare scenario where you have a stalking case where no technology is used whatsoever. And one thing that can be very helpful is to find a tech expert in your area. So that could be your local police, it could be the AG's office, your state police, the FBI, and we'll leave you with some resources today as well that you can reach out to. But find that tech expert, and it can help walk you through not only how to preserve it, but how to get it off the device and exactly what it is. A lot of companies are ready and willing to help you get that information. So if you have information on a social networking site and you need to get it, they're usually really great about working with law enforcement and or prosecutor's office. They're less probably likely to want to work with either a victim or a subscriber if you're dealing with like an internet provider. But one thing to know is that you have to know what their protocols are, what are the proper channels that you need to go through, and what information has to be in that subpoena when you send that off. And again, you can look to the internet providers. They're usually pretty good about responding to those types of subpoenas. Just be sure that you're following exactly to a T everything that they require on their end, and you should be fine. When you're dealing with a legal response team, that team can tell you what information they have, how long they keep it, exactly what needs to be in that subpoena and how it needs to be worded. One thing that you may want to consider, though, is if you're dealing with a situation where the offender is either going to be put on notice that their account is being looked at by law enforcement, or if the account is now suspended and the offender is locked out of their account, again, that puts the offender on notice, and that can escalate the behavior. And so one of the things that you should consider, probably what's going to drive your decision ultimately with what type of information you're going to seek, is your victim safety. And so, again, if this is something that's going to alert the offender and potentially cause escalation in behaviors and put your victim at risk, maybe this is something that you don't do, or you find a different way to go about it. And then you want to be sure to be asking how long will it take to get that type of information, because if you're dealing with something where you're up against the clock and you need that information, one thing you can consider is using the victim to get their own information. And while it's less formal than, say, a subpoena, it certainly can be helpful and very useful, especially, again, if you're up against the clock. So victims' records often have information around your offender, and some of that, as John had mentioned, can be circumstantial, so it can link you back to that defendant. If you look at the email headers and you expand them, you'll see the IP address, and that's something that can't be changed. So, again, if you can trace that back to the offender's computer. Again, you're still going to have to use circumstantial evidence because inevitably the offender is going to say he or she didn't type that message. But again, you can at least start the process of going back to the offender and connecting it. Look for that non-public information, maybe information that is only between your victim and defendant, things that only were sent to the victim and not posted, say, on a public Facebook page. And your victim really can aid you in that circumstantial evidence. They typically know where the information is coming from, and they can provide you those clues that they know why it's the defendant that's sending it to them. And don't forget about just good old public information. You don't need a search warrant. You don't need subpoenas. You don't need any type of consent to do these types of searches. And so if it's Google, if you're looking at things that are posted on a public domain, that can provide you with a lot of information as well. One thing just to note is that your best evidence, as John had mentioned, is going to be when it is in the original form. And I don't mean, again, best evidence rule, but just that when it's in its original form and there's no opportunity for it to have been altered. This is going to preempt the challenge of authenticity. John?
And just a couple of things to think about when you're doing these cases. The Stalking Communication Act covers a lot of ways to get different levels of information through subpoenas. Subpoenas plus notice, which is akin to what Elaina was talking about. The notice is required to be given to the subscriber by the provider, the internet service provider, or whomever you're contacting that controls that website. And you can delay that notice for up to like 90 days. The same with the orders and the orders plus notice. They give you different levels of information. A search warrant is going to be the best thing that you can do. It just depends on how much probable cause you've been able to develop to establish that there's evidence of a crime contained in someone's computer or not. But anyway, you can delay those notices to not tip off the offender. Again, as Elaina mentioned, victim safety is going to be a key in those cases. But if you're just investigating, you probably may not want to tip them off in that case. The search warrant, again, obviously like any other search warrant, you have to have some probable cause. There's no notice to the subscriber, and you can get everything that they have. We can provide you with some sample language if you want for a search warrant, or just want to look at what sample language we have compared to what you guys are using. Again, you want to think broadly about how people communicate, what kinds of communications have come. If it's a computer, is it his home computer? Is it a work computer? Is it sent from a mobile device but looks like it's coming from an email, or is it indicated that it's actually an email that's being sent from a mobile device? How many phones does an individual have, a work phone, a personal phone? Just make sure we cover everything wherever it could possibly be coming from, wherever somebody could access an account. And then we probably want to use a tech expert at trial, particularly if you're going to have to track down, if it's not obvious or the victim can't tell us, yeah, that's his email address, or yeah, that's his telephone number. And we can't establish it through the victim, we may need an expert who's going to track down and establish that, or it might be your officer who can do that through the tools that they have to electronically investigate these cases. But an expert can always be a powerful witness because it can demonstrate this complex or complicated evidence in a very simple way. You've got to make sure that they clearly and carefully explain things to jurors so that they understand what they're talking about, because some people are overwhelmed by technology. Other people think they know a lot about technology and don't, and they're even more dangerous. So think about those things. And then there's a lot of assistance out there for these cases. The U.S. Attorney's Office has people dedicated to prosecuting computer hacking and intellectual property that can assist you. And then they have their computer crime and intellectual property section that you can call into and gain assistance with them too.
And if you're working with a victim who has things out there on the internet and you want to try to remove some of that information, search.org is a good resource to look at. If you're a victim advocate working with a stalking victim, there's a specific site that you can go to where they will help remove that information for free for victims of stalking and domestic violence. Bear in mind that the Department of Justice also puts out several publications that might be helpful for you to look at. And the National Criminal Justice Reference Service also publishes a PDF on investigations involving the internet and computers. So you may want to check that out as well.
And then just lastly, going forward, as we think about these cases, they can be tough cases to investigate. They may take some time. They may take some support of the victims and things like that. When technical evidence or technological evidence is involved, we really want to pay attention to what's going on. We want to identify it. We want to obtain it, an accurate copy of what we're talking about. We want to be able to establish the authenticity and tie it to the offender to make sure that it's relevant. We want to introduce and explain the evidence effectively at trial, which may involve the use of an expert, someone who can explain these things to a jury adequately, or a judge. If you don't have a bench trial, a lot of judges suffer the same thing that a lot of us do when it comes to technology. It's very difficult to understand, or it just makes us nervous because we don't understand it typically, even though people can explain it very easily. And we want to anticipate some of these common objections and be ready to answer and respond to them, because we've done our thorough investigation where we've established the authenticity of what we're trying to introduce and that it's relevant because it came from the defendant. And so some of the things we have to think about is investigating these cases from the get-go effectively by establishing circumstantially that this had to have come from the offender, and it couldn't have come from anybody else, either based on content or based on things that they tell us about the device that was used at the time the message was sent, their ability to control the device through passwords and their exclusive use or possession of those devices, and that no one else uses or possesses those devices. So think about those things as we try and go forward in these cases, and hopefully we'll be more successful in these cases.